Hello everyone, welcome to Drishti IAS. I'm back with another episode of Revision with MCQs, and today we are going to cover the subject of polity with the help of practice questions. So without further ado, let's take a look at the very first question. Consider the following statements. 1. In the Champakam Dorai Rajan case, 1951, the Supreme Court held that fundamental rights can be amended for implementing directive principles. And second, in the Golaknath case of 1967, the Supreme Court ruled that in any conflict between fundamental rights and directive principles, the latter would prevail. So if we consider the first statement and look at the Champakam Dorai Rajan case, this case actually dealt with the conflict between fundamental rights and directive principles of state policy. And the Supreme Court held that in case of any conflict between the two, between fundamental rights and directive principles of state policy, actually the fundamental rights would prevail and the DPSPs or directive principles of state policy would remain subordinate to or subservient to the fundamental rights. So this statement is incorrect. When it comes to the second statement, in the Golaknath case of 1967, here again the Supreme Court said that in between or out of the fundamental rights and DPSP, no amount of or no constitutional amendment can abridge, amend or take away any of the fundamental rights for implementing the directive principles. So here again, the superiority of fundamental rights or the sacrosanct nature of fundamental rights was made very clear by the Honorable Supreme Court. Finally, in the Minerva Mill case, the Supreme Court held that the fundamental rights as well as the DPSPs are supposed to be harmonious, like the balancing wheels of a chariot. So they have to run in sync, in harmony, rather than one trying to subdue the other or vice versa. All right. So again, both these statements are incorrect, and therefore we have option D, neither 1 nor 2 as the correct answer. This is the explanation in detail. Kindly pause your video and read it. The second question says the provision for separating the judiciary from the executive is included under which part of the Constitution? So it's a very straightforward question. This is included in the directive principles of state policy, which is part 4 of the Indian Constitution. So answer C is the correct answer, and this is included in Article 50. So a very straightforward question with a straightforward answer. All right, let's move on. Question 3, with reference to the directive principles of state policy, consider the following. 1, to secure opportunities for the healthy development of children. 2, to make provisions for just and humane working conditions and for maternity relief. 3, to take steps to secure the participation of workers in the management of industries. And 4, to protect and improve the environment and safeguard forests and wildlife. How many of the above were not part of the original Constitution? So basically, if you look at the very first statement, to secure opportunities for the healthy development of children, this was added under the 42nd Constitutional Amendment Act of 1976, and this is Article 39. Then under the same Constitutional Amendment Act, that is the 42nd Constitutional Amendment Act, Article 39A was also added, which empowered or which directed the state to ensure legal justice and to ensure free legal aid to the poor. So Article 39A was also added over here. Then the next constitutional amendment, which was the 44th Constitutional Amendment of 1978, added this one: to take steps to secure the participation of workers in the management of industries, and this was Article 43A. Then again, to protect the to protect and improve the environment and safeguard forests and wildlife was Article 48A. So this was also added later. Now, another Constitutional Amendment Act, which is the 86th Constitutional Amendment Act of 2002, elevated the right to elementary education as a fundamental right, followed by the 97th Constitutional Amendment Act of 2011, which did what? Which asked the state or directed the state to promote cooperative societies, to encourage their voluntary formation, to enhance their democratic control and professional management. So far, so many constitutional amendments have been made, which have added various articles to the directive principles of state policy. But the second article, this one, to make provisions for just and humane working conditions and for maternity relief, was a part of the original constitution. So here, not part of the original constitution, only 3, and therefore option C is the correct answer. Please take a moment and read this. Fourth question, consider the following statements regarding fundamental duties. 1, they help the courts in examining and determining the constitutional validity of a law, and second, they are enforceable through laws, allowing Parliament to prescribe penalties or punishment for their non-fulfillment. Now, what were the fundamental duties derived from, or which country inspired India to include the fundamental duties? It was the USSR. And when were the fundamental duties included? In the 42nd Constitutional Amendment Act of 1976. And then further, later on, an 11th fundamental duty was also added. Now, the thing is that there was a Swaran Singh committee that was set up to examine the scope of fundamental duties, and it recommended 8, whereas we adopted 10. All right. And the thing is, even though these fundamental duties are not mandatory, yet they remind the citizens of the duty that they owe towards the nation, to its unity and integrity, and towards its fellow citizens. So here, another thing is that they also help the courts in examining and determining the constitutional validity of laws. So they definitely come and aid the court in determining whether the law is constitutional or any law is constitutional or ultra vires. All right. So even though they are not justiciable, but they do help in determining the constitutional validity of law. And secondly, of course, they are enforceable through laws. And if the Parliament passes a law mandating the conduct of an or observance of a fundamental duty, then the failure to do so may also invite penalty. So both these statements are correct, and therefore we have option C as the correct answer. Now here in the explanation, Mohan Kumar Singhania case is important because here the Supreme Court held that Article 51A, this is the article for fundamental duties. This article can be invoked to interpret ambiguous laws. So this case, Mohan Kumar Singhania case of 1991 is fairly important. Fifth question, with reference to fundamental duties, consider the following types of diversity. 1, religious diversity. 2nd, linguistic diversity. 3rd, regional diversity. And 4th, economic diversity. How many of the above are explicitly mentioned in the fundamental duty to promote harmony? So now we discussed already that fundamental duties are contained in Article 51A of the Constitution. And amongst various fundamental duties, there is one which requests or which asks the citizens to promote harmony and the spirit of brotherhood among the citizens. By doing what? By transcending. By transcending. What is transcending? Transcending means, in simple words, by going beyond. So by transcending religious linguistics, religious, linguistic, regional, and sectional diversity. All right, so we have to, as citizens of the same country, rise above and beyond religious diversities or linguistic diversities or sectional diversities or regional diversities. All right, so here, of course, we have religious, linguistic, and regional diversity that has been mentioned in the article. However, economic diversity has not been mentioned, and this is the odd one out. How many of the above are explicitly mentioned? Only 3, and therefore option C is your correct answer. Please pause the video and read the explanation in detail. Next question, consider the following types of majority. 1. Simple majority of parliament. 2. Special majority of parliament. 3. Special majority of parliament along with ratification by half of the state legislature, and 4. Effective majority of the parliament. How many of the above are types of majority mentioned in Article 368 of the Constitution? So Article 368 in Part 20 of the Constitution deals with constitutional amendments, and it mentions 2 types of majority. 2 types of majority that are required for amending the Constitution under article, or for the purpose of amending the Constitution under Article 368. And those 2 types of majority, as mentioned, are special majority and special majority plus ratification by half of the state legislature. Half of the state legislatures. Now, naturally, this second provision, ratification by half of the state legislatures, is required especially when an amendment to the federal structure or an altering of the federal balance of power is required. All right, only then does this type of majority is required for being exercised. Now, these are the 2 types that have been mentioned. What is special majority? What is meant by special majority? When I say special majority, it means majority of the total membership of the House. Total membership of the House, irrespective of vacancies and absentees, plus 2/3 of the members present and voting. This is understood as special majority. In some provisions or in some amendments, we also need, like I just told you, ratification by half the state legislatures. Then, of course, simple majority is mentioned. Simple majority is simply the majority of the members present and voting. Then we have effective majority. Effective majority means majority of the then members of the House, then membership of the House. And this we have studied in earlier episodes, that this kind of majority is important for the removal of the Speaker of the Lok Sabha, right? Or the Chairman of the Rajya Sabha. This kind of majority comes handy, whereas ordinary legislations are passed by the simple majority of the parliament, right? So the correct answer is option B, only 2. Special majority and special majority along with ratification by half the state legislatures. Now here is the explanation in detail. Kindly pause this and read it. Question 7. With reference to constitutional amendments, consider the following provision. 1. Procedure of election of the president. 2. Distribution of legislative powers between the union and the states. 3. Any of the lists in the 7th schedule. 4. Representation of states in parliament. 5th. Conferment of more jurisdictions on the Supreme Court. 6th. Abolition or creation of Legislative Council in states. The question asks you, how many of the above require amendment by a special majority of parliament along with the consent of at least half of the states? Now, just in the preceding question, I told you that when we are talking about Article 368 and the amendments contained therein, then there are two types of majority that are required. One is the special majority. The other is special majority plus consent of half the states or ratification by at least half of the states. Now, please remember, when we talk about ratification of at least half of the states, then there is no fixed deadline or fixed time period within which the states have to consent. Now, where did I tell you that you need this kind of a majority to carry out an amendment? Where the federal structure is in question, or there is an alteration of balance of power between the union and the states. So let's consider these options one by one. So procedure of election of the president. We know that when we talk about the procedure of the election of the president, then of course we have the method by which both the elected members of both the houses along with elected members of the state legislative assemblies are involved. So of course, here, since state legislative assemblies are involved, we do need ratification by states were such a procedure to be changed. Then the second one is distribution of legislative powers between the union and the states, very directly altering the federal feature. So therefore, of course, this would require ratification by the states. The third option says any of the lists in the 7th schedule, again, whether it's the state list, the union list, or the concurrent list, of course, directly impacts the federal structure and the balance of power, and therefore would require ratification by the states. The fourth point says representation of states in parliament, directly talking about states. So that representation would naturally require ratification by states, right? Half of the states. Then the fifth one says conferment of more jurisdiction on the Supreme Court. Now, when we talk about conferment of more jurisdiction, then this can be simply done by a parliamentary law, all right, by simple law passed in the parliament. However, if we were to be dealing with, let's say, changes under Article 131, which is the original jurisdiction of the Supreme Court, then of course, we would perhaps require the ratification by states. But simply changing or altering the jurisdiction, enhancing it or diminishing it would not really require the involvement of states, and therefore this we will exclude. And the next one is abolition or creation of legislative councils in states. This we again know does not fall under Article 368 as a matter of amendment. We know it for a fact, right? So this is carried out again in the parliament. So this also can be excluded, and here we have only 4, or option C as the correct answer. So there are these 4 options that would require the ratification of states, whereas these 2 will not necessarily need that ratification. So here is the explanation in detail. Please read this. Next question, which of the following was not declared as part of the basic structure of the constitution in the Kesavananda Bharati case of 1973? Now, Kesavananda Bharati case of 1973 is a landmark judgment, because here the Supreme Court evolved the basic structure doctrine. Basic structure doctrine, and a 13-judge bench was instituted to arrive at this doctrine. I mean, it was not instituted to arrive at it, but well, the 13-judge bench evolved something that you can call the basic structure doctrine, which involved a lot of things, right? So, of course, it talked about the parliamentary form of government. Then it also mentioned the secular nature of the constitution, right? Or the federal nature of the constitution. Then it talked about the republican and democratic form of government. All these, it said, were a part of the basic structure of the constitution, which means that no right or no law that changes the basic structure of the constitution will be considered as constitutionally valid. That is the whole idea behind the basic structure. All right. So here, of course, secular character of the constitution, parliamentary system of the constitution, then the federal character of the constitution, all of these did involve or were listed as the basic features of the constitution by the Supreme Court in the Kesavananda Bharati case. However, in the 1975 Indira Gandhi Nehru case, the Supreme Court held that the rule of law and not the rule of men is also a basic feature of the constitution. It forms a part of the basic structure of the constitution along with judicial review. So these two were held out or listed out expressly in the 1975 Indira Gandhi Nehru case. All right, or Indira Nehru Gandhi case. So rule of law was not listed in 1973, and therefore option C is the correct answer. Here is the explanation in detail. Please take a look at it. Penultimate question, consider the following statements regarding mutual delegation of executive functions between the center and the state. Now, here is the thing. The constitution is fairly rigid when it comes to the distribution of functions between the center and the states. However, under some circumstances, this mutual delegation is permissible. Let's consider the statements. 1. The president may, with the consent of the governor of a state, entrust that state government with any of the executive functions of the union. Whether this statement is correct or not, let's just look at it in the detail. Now, under Article 258, Clause 1, the president may, with the consent of the state government, not the governor of the state, the state government, entrust that state government with any of the executive functions of the union. So this indeed is possible, of course, under certain circumstances. However, the consent of the state government is required, not the governor. And this happens under Article 258, Clause 1. Therefore, this statement is incorrect. The next statement says the governor of a state may, with the consent of the central government, entrust the union government with any of the executive functions of the state. Now here, of course, we are asking about or talking about the governor of the state, and the consent of the central government is involved. So if the governor of the state requests the central government with its consent, then some of the functions of the state can be entrusted upon the union government. So this statement is accurate, and this is accurate under Article 258A. All right. So here we have option B, 2 only, as the correct answer. This is the explanation in detail. Please take a look. Final question, which of the following is not mentioned in the second schedule of the Constitution of India? So what does the second schedule of the Constitution of India consist of, students? It consists of salaries and allowances of the following officials. Who all are they? First of all, the President of India and the Governor of States. So you can actually draw some sort of a congruence over here, right? President of India and Governor of States, kind of a parallel position at the level of the union as well as of the states. Then we have the Speaker and the Deputy Speaker of the Lok Sabha, followed by the Speaker and the Deputy Speaker of state legislative assemblies. Then, of course, we have Then, of course, we have the chairman and the deputy chairman of the Rajya Sabha. Your chairman also is the vice president, followed by the chairman and the deputy chairman of state legislative councils. Then we have the salaries, emoluments, allowances of the judges of the Supreme Court, followed by the judges of the High Court, and finally the CAG, your Comptroller and Auditor General. Now, if you take a look at it, then you'll realize that a parallel or a congruence can be drawn so that you can easily remember all of this. So then, of course, we have containing the emoluments, salaries, allowances for the President of India, the Governor of States, your Speaker and Deputy Speaker for Rajya Sabha, Speaker and Deputy Speaker for your states. Then you have the Chairman and the Deputy Chairman for the, I said Rajya Sabha, it's meant to be Lok Sabha. Then we have the Chairman and the Deputy Chairman for the Rajya Sabha, followed by the Chair and Deputy Chair for your state legislative councils, Supreme Court judges, High Court judges, and finally the CAG. So now that we have this in mind, let's try and solve this question. Does the second schedule contain the mention the Speaker and Deputy Speaker of the Lok Sabha? Indeed it does. It also mentions the Governor of States. Does it mention the Attorney General? It doesn't. And finally, the Chairman and Deputy Chairman of the Rajya Sabha is also mentioned. So, since Attorney General is not mentioned, option C is your correct answer. I hope this is clear. Here I have a practice question for you. Please read the question. Please do send me your answers in the comment section. If you liked today's video and you found it useful, please hit the like, share and subscribe button, and thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.